welcome back. This is our fourth tips on estate planning, little 2.5 minute video. We're going to talk about some horror stories of not checking up on your beneficiaries being named in your trust properly. There's a very well-known, documented true story about how a husband and wife got married in their late 20s, and she was a school teacher, and before she met her dream boy, she named her parents and her sister as the heirs in her 401k. Because of his job, they decided to save everything in her 401k, and that was their main saving spot. Well, fast forward about almost 40 years later, she dies, okay, of a heart attack as a principal in a school system. And when he goes to file to collect the 401k, he's shocked that he doesn't get it. Yes, her parents had already passed on, but the sister was the remaining naming in the 401k, and as a result, she inherited all $940,000. Quite a shock to him, to say the least. And even though they sued, the judges shook their head and said, "I'm sorry, the law is the law," and she gets the $940,000.
And another example, Carl, this is not a true story, but it's one that could happen. We talked in a previous video about the Secure Act. Under the Secure Act, all money paid out to a non-spouse beneficiary has to come out within 10 years. Well, if you have a client, many clients have set up trusts to be the beneficiary of their IRA or 401k because they have spendthrift children or maybe children with a special need that requires them to get guidance as to how that money is taken out. Many of those trusts, though, are designed to only pay out the minimum required distribution. So
Right.
If I have my trust named as a beneficiary, I die, and it's paying out the minimum required distribution, guess what? Under the Secure Act, there really aren't any required minimum distributions other than in the 10th year. And in the 10th year, it's required that everything get paid out. So if you have a child who's a spendthrift, perhaps has addiction problems, or maybe has special needs, they could have a situation where if that trust for them is set up as the beneficiary, in the 10th year, they're going to get a windfall. And that could be just a terrible situation if you're really trying to protect that child from a large inheritance coming all in one large fell swoop. So again, so important to regularly review who are your beneficiaries. And I would also add, get verification. I had a client who put money in an IRA with a bank. The bank changed ownership multiple times. They died, and at death, the successor bank did not have record of a beneficiary on file. And if you don't have a beneficiary on record, everything has to come out over 5 years. And so, there was about an $800,000 IRA that had to be paid out over 5 years. All the tax had to be paid, and it was a real nightmare. So again,
Wow.
Can't emphasize enough, review your beneficiary designations on a regular basis. And do it not only with your estate planning attorney, but with your financial advisor as well. And if they work together, that's a way that we can find these gaps in your plan and really make sure that you're not going to have one of these catastrophes fall upon your beneficiaries.
Exactly.